Okay. Okay, the main room is being recorded. The main room. Okay, what is the main room? Maybe it's this room. Okay, maybe it's the lecture slides. Okay. Well, anyways, let's see how it goes. So let me prepare the slides over here. Okay. As I move the slides, you cannot see it moving. Okay. Let's stop sharing. Let me share again. I'm gonna share second screen. Yes, share. Okay. Okay, so now you can see it. You can see it moving. All right. So lecture number 1. So our last class, we started with the very basics in the course, meaning we looked at definitions of law. Then we went through some categories of law. So you should know the categories: substantive, procedural, public, private. Then we went through the legal systems. So there's the civil law legal system in Quebec only for non-criminal matters. And then there's common law system everywhere else. And common law will be focusing most during this course. The civil law legal system, the main characteristic is that there's a civil code, and most laws are in the civil code. Judges will interpret the concepts and principles in the civil code. Whereas in the common law system, the main characteristic is that judges, they make law. Some of their decisions, not all, but some decisions, they become law, they become precedents, they become case law. And then some judges, they are required to follow those decisions, as you know, based on the stare decisis principle. Now, today, it's going to be clear because, as I told you last class, only judges from lower courts are required to follow those concepts or the case law or those precedents. So when we go through the case law today, or court hierarchy today, it's going to be clear to you. Now, judges, they make law. Some judges make law. Some case law become precedents. But in common law system, there's also written law, as we know, statutes made by the legislative branch, made by politicians. They could also be made by the government, by the executive branch, regulations, bylaws. So we also looked at constitutions. So 2 constitution acts that are important for us. The first one, the 1867 one, that created Canada as a country, separated powers between federal and provincial governments, Section 91 and 92. Also brought the rule of law to the country, so no one is more important than the other. The law has to be applicable equally to everyone. Now, the Constitution also established those 3 branches or 3 powers for the system of government, and they are the judicial branch, courts. So judges, they render disputes, and they adjudicate disputes, they render decisions, and they also make law. The executive branch, that is formed by the prime minister, their cabinet, and the premier in the provincial level, and their cabinet. They manage the country, they manage the provinces and territories, they run the country. They also make some laws that are called either bylaws or regulations. But these, they are dependent on the statutes, on the main act. And the statutes, they are made by the legislative branch. That is the parliament in the federal level, or the provincial legislature in provincial level. So those are the 3 branches. I told you that no one is more important than the other. Each one has their own role. But the Constitution Act of 1982 brought the Charter of Rights and Freedoms, made it to be of constitutional level, and they increased the power a little bit of the courts, because now the courts have the final word whether governments have violated our rights, abused on our rights or not. So then after constitution, those two constitutions, we went through the Charter of Rights and Freedoms, and you should remember that the Charter is only applicable when governments, could be federal, provincial, when they violate on our rights. So remember it's section 32(1). Charter is applicable only to governmental activities. And then we have the human rights legislation. So human rights is when people discriminate one another, or private entities, private companies discriminate on others. So we apply the human rights legislation. Now, when there's a violation of the Charter, we go to courts. We sue the government for that violation, and then the courts will have the final word. Now, when there's a discrimination under human rights law, we don't go to courts. We file complaints against the wrongdoer, against that party who allegedly discriminated on us. So complaints are filed with the Human Rights Tribunal, and the Human Rights Tribunal will render a decision whether there was discrimination or not. So in very nutshell, this is a review from chapter 2. Now, in chapter 3, we'll continue on the basics of the legal system, but now we'll move to disputes. So now, based on our understanding of what a law is, their categories, the legal system, so basically for us, common law, how the importance of the Constitution, the powers or branches, legislative, executive, and courts, but for us, more important, the courts. Now that we know this, we move to disputes. So if we have a dispute with someone else, if we have a dispute with a company, so any disputes, any issues, so someone may owe us money, or we may be working and it may be that our employer terminated our employment agreement without any notice, or could be that you are driving and you suffer a minor accident, but still the other party didn't pay for the damages you suffered. So any kinds of disputes. We're going to talk about disputes. Could also be human rights discrimination, could be a violation of the Charter, etc. So we'll go through this resolution of disputes, how disputes are solved in Canada, or what are the ways disputes are solved. So we're going to start by looking at the alternative methods to solve disputes in Canada, and they are mainly negotiation, mediation, and arbitration. And then we'll move through court litigation. So litigation, litigating in courts, starting a lawsuit. But before we learn about the litigation, the lawsuit process, we'll go through the court hierarchy and some concepts there as well. So let's, and then we'll end the lecture by talking about regulatory bodies and administrative tribunals. So an example of an administrative tribunal is the Human Rights Tribunal I told you about. So let's start with the alternatives to court litigation. Well, the key word here is alternative. If it's alternative, parties may choose to go through them. Parties are not obliged to. Parties are not required to. Well, there are some few exceptions in the law in which parties have to go through mediation before they can start a lawsuit. But that's not the general rule. The general rule is that if you are faced with a dispute, you can use these alternative methods, but you don't have to. So the first important aspect here for the alternatives to court litigation, it is that they require an agreement. Parties need to agree, the disputing parties, they need to agree to submit their dispute or to try to solve their dispute through any of these alternative methods. So that's the first important aspect here. And then let's think about a practical matter here. Let's say you have a dispute with your neighbor. Your neighbor is listening to loud music every night. So from midnight to 3 a.m., they listen to loud music and it's bothering you. Well, it's a dispute. They do what they want. You cannot rest. What is the first thing we usually do? We interact with them. We talk to them. So we usually try to negotiate. So that's negotiation. Negotiation is when both parties, both disputing parties, they interact with one another and they try to find an outcome that is good for both parties. Well, it may be the case that you negotiate with your parents, with your partner, with your children, neighbors, family members, employers, friends. So we actually negotiate on a daily basis or on a very regular basis when things are not okay. It could be that students want to negotiate with the instructor, deadlines, requirements, etc. So that's what negotiation is. And we already know what it is. Now, keep in mind, you cannot be forced to negotiate a dispute. If you don't want to, you can't be forced. Okay? So that's the first thing I had mentioned to you. Now, second thing of importance here in the legal aspect, the outcome of the negotiation is not binding, is not mandatory. So let's say you purchased products from a supplier. Those products arrive to you with quality issues. So you start negotiation. Even though there are quality issues, you can still keep the products, resell them, but you negotiate with the supplier that in your next order, you will get a discount. You will get a credit of certain amount. Now, when you place a new order, if they forget about it, or even if they remember, but they don't give you the discount that was negotiated with you now, you cannot force it on them. You cannot enforce on them. So again, the outcome of the negotiation is not binding. Now, one question for you. How can you make the outcome of a negotiation binding if you want to? What do you think? Think about the example I gave you. How could you make that binding, mandatory on the supplier to give you the discount?
You can put that in a contract, maybe an agreement,
You can put that in a contract, maybe, or
anyone there? Proper documentation, put in a contract. Yes, that's right. Not necessarily documentation here would be the contract or the agreement. Yeah, can I not hear you? Are you using? Has anyone tried to use the audio? I think I have my. Yes. Oh, sorry. So okay, let me just check my audio here. Thanks for bringing this to my attention. Okay, when I connected my second screen, it's changed. Okay. Can you try again? Can someone try to speak, please?
Hello.
Oh yes, now I can hear you. Thank you.
Can you hear me now? Can you hear me now?
Yes. Yes, I can.
Okay.
Thanks.
I tried a couple of times.
Oh, sorry about that. Yeah, because when I got the second screen, it moved to that second screen speakers, but then I just didn't realize. All right, so yes, you can put this in a contract. That's right. Then, if the supplier in this example does not give you the discount in the next order, it means that they are breaching the contract. They are not complying with the agreement. Then you can sue them under contract, under breach of contract. So remember I told you, I'm not here to teach you to be lawyers, but to share law with you on a legal risk perspective. So this is one lesson we get from negotiating disputes with other parties. To make sure or to increase the chances that the outcome will be complied with, after you negotiate something, put that outcome, that negotiation terms in a contract, and then have both parties agree to that contract, so that if they fail to comply, you can go after them. Okay, this is not legal advice. Remember, I cannot give you legal advice, but this is sharing legal information with you on a legal risk perspective. So that's what negotiation is. Again, straightforward. We negotiate on a daily basis. I don't know your case, but I negotiate with my wife on a daily basis. She wants me to do house chores. Sometimes I don't want to, or she wants me to go grocery shopping. I don't want to. We start a dispute. We negotiate. So we negotiate. Those are things. Good news for me is that she hasn't taken this course, so she doesn't know that the outcome is not binding. So if I agree and then I don't do it, she cannot come after me. If she wants me to sign a contract, no way, I wouldn't sign it. Just joking here, but that's how it is, okay? Negotiation. Now we move to mediation. Well, you don't need to go through negotiation. If negotiation is not successful, then you will choose mediation. No, those three types, they can be used at any time interchangeably. But common practice is that parties usually go through negotiation. If negotiation is unsuccessful, then they go either through mediation or they go straight to arbitration eventually. So now, what is mediation? Mediation is very similar to negotiation, except that in mediation, there will be a third party. This third party is a neutral party. So let me just bring here to mediation. So there will be a third party trying to help the parties, the disputing parties, to find a solution. Now, attention, the mediator will not make a decision. No, the mediator will use their mediating skills, negotiation skills, psychological skills, any other skills to try helping the parties reach an outcome themselves. Now, because it's similar to negotiation, the conclusion is that the outcome of mediation is not binding either, is not mandatory on the parties either. So again, to increase the chances of enforceability of the outcome, it's advisable that parties have the outcome in writing, in an agreement. Now, so let's think about a practical example here. So let's say my wife and I, we have a dispute. We tried to negotiate. We were not successful. The dispute is a bit more serious. So we now want to have a mediator, a neutral third party to help us out. Could be a counselor, could be a psychologist, could be a religious leader. It couldn't be my mother-in-law, because my mother-in-law would be biased to my wife. But it should be a third party. And it's better if it's a neutral third party. Could even be a neighbor eventually. Okay? And then they will function as the mediator, trying to help the disputing parties to find an outcome. So that's what mediation is. Now, the last one will be arbitration. Well, arbitration is more adversarial. Arbitration is similar, not the same, but it's more similar to a litigation, to court litigation. Because in arbitration, parties, they do not interact with one another directly anymore. parties, they will actually, the disputing parties, they will actually submit their claims, their evidence to an arbitrator. The arbitrator is a decision maker. The arbitrator will make a decision based on the dispute, the evidence presented to them, and the decision of the arbitration, that is called an arbitration award, that decision is binding. That decision is mandatory. If the losing party does not comply with the arbitration decision or the arbitral award, the winning party can ask the court, because an arbitrator does not have this power, but a judge from a court does have this power. So the winning party would ask the court, the judge, to order the losing party to comply with the arbitration decision, with the arbitral award. Okay, so that's why it's more similar to court litigation, even though it's not court litigation. So that's what arbitration is. Now, an important aspect on arbitration specifically, just arbitration. When parties choose arbitration, again, when parties choose arbitration, they are waiving their rights to go to courts. They are saying no to courts. This is very important because once you agree to arbitration, if you change your mind later, you cannot go to courts unless the other party agrees. But if they don't agree, you have to stick to arbitration. In other words, this also tells us that if we don't like the arbitration's decision, we have no remedies. We cannot go to court. We cannot appeal it to court. No. Once you choose arbitration, you have to stick with arbitration. Again, from a legal risk perspective, from a legal information perspective, when you are to decide to arbitration, make sure you make an informed, voluntary decision about arbitration. Make sure you know the characteristics of the arbitration. Make sure you know who the arbitrator may be, what the rules of the arbitration will be. Because once agreed upon, you cannot change your mind. Okay? So that's very important about arbitration. What else? Well, usually the decision of the arbitrator cannot be appealed. Usually, that's the general rule. So the decision of the arbitrator is final, no appeal. But I say usually, I say the general rule, because there are some arbitration tribunals, and those are private institutions. There are some tribunals that allow, their procedures allow for an appeal. Well, you would need to be aware, you would need to learn about those specific arbitration tribunals procedures to learn whether there's an appeal available or not. Now, the arbitration process, so I made it bold for you in the slides. The process may be reviewed by courts, not the decision, not the merits. So by process, I mean, let's say the arbitrator was biased. Let's say the arbitrator did not give one of the disputing parties an opportunity to present their evidence. Or let's say the arbitrator took too long, or any issues in the process of the arbitration can be reviewed by courts. But usually in most cases, the courts will not review the merits. They will only review the process. Now, just getting back here to some advantages and disadvantages of either of them, negotiation, mediation, and arbitration. So most advantages will be related to lower costs and control of the solution. Well, if you negotiate something, you have control of the solution. You have control of whether you reply to the other party's request today or tomorrow. Well, you and the other party control. Now, if it's litigation, for example, well, you don't have control. You have to follow the court's procedure or the rules of procedure, etc. So that's why we say there's more control for the parties to deal with their dispute. Also, lower costs, usually lower costs. If you are negotiating something, there's actually no costs at all, unless you engage negotiators, lawyers to help you negotiate, but usually no costs. And usually the goodwill is preserved. Well, goodwill meaning the good relationship. There was an issue with the supplier. Instead of suing them right away, I call them, I visit them, I try to negotiate a good settlement or outcome for that dispute. So usually the goodwill is preserved. Now, some disadvantages is that only courts have power to extract information, to extract documents, etc. So if you are in an arbitration, for example, and the other disputing party is not releasing an important document for the dispute so that the arbitrator can make their decision, the arbitrator does not have that power. In principle, as a general rule, there are some exceptions. So this is known to be one of the disadvantages. Courts do have power to extract information in ADR, in alternative dispute resolution methods, not necessarily. Decisions do not follow a precedent. So only common law courts will follow precedent. They are required to follow, but arbitration, no. Negotiation, not at all, not even mediation. And there's usually no public record. So it's private, meaning that we don't know how an arbitrator decides, how legally knowledgeable an arbitrator is, etc., because there's usually no public record unless parties want to make their dispute public. So that's negotiation, mediation, and arbitration. So they are alternative to courts. One last thing I want to share with you is, let me just get a web browser here. Let me bring the web browser here. Okay, so I want to share an example of VANIAC with you. So VANIAC is this Vancouver International Arbitration Center. Just disclaimer here, I'm not affiliated with them. I'm just sharing their information as news to you, just as a practical example. So VANIAC is this private arbitration tribunal. In other words, they offer arbitration services, mediation services. They even offer services for motor vehicle cases. They will have a list of panelists or mediators, arbitrators. They have their resources here. So if you ever agree to an arbitration through VANIAC, it is important that you come here and you understand the rules of procedure. What are the rules of procedure? You may also want to know what their costs will be, because there will be costs related to it. Now, when there's an institution like this tribunal, we call it institutional arbitration or institutional mediation, because there's an institution behind it. There's an institution that will provide those services, okay? But there could also be, it's called this Latin expression, it could also be an ad hoc arbitration or ad hoc mediation. An ad hoc means that the arbitrator or the mediator, they are not affiliated, or for that specific dispute, they are not affiliated with a specific institution. So it's like, let's say, you and your partner have your neighbor that is a good friend of yours as a mediator for a dispute you may have. So that mediator, your neighbor, they are an ad hoc mediator because you did not reach out to an institution for that dispute. Now, something else I want to share with you is an example of a clause. So remember, I told you initially in the very beginning, parties cannot be forced to go through either arbitration, mediation, or negotiation. So usually parties will agree in a contract. So for example, they will usually have this combined. If the dispute cannot be settled within 30 days after the mediator has been appointed, then parties agree that the dispute shall be referred to and finally resolved by arbitration. And then it goes on saying that that arbitration will be administered, also the mediation, by this institution, by the Vancouver International Arbitration Center. And then it also talks about the place of the arbitration. So arbitration will be here in Vancouver, BC, Canada. Now, there are many famous and important mediation and arbitration tribunals worldwide. There's ICC in Paris. There's a famous one in New York, London, Hong Kong. Well, many cities in the world may offer those services. So if you want to add, if you want to propose either arbitration, institutional arbitration or mediation in any relationship you may have, it's very important that you understand what the rules are, costs are, and understand more about those institutions. Okay, so that's here just an example I wanted to share with you. So about institutional arbitration. Any questions? Any comments? No? Are you following? Okay, so what I'll do now is I'm gonna pause the recording here. All right, so now let's talk about court procedures. Where's my mouse? Okay. So we talked about solving disputes out of courts through negotiation, mediation, or arbitration. And now we'll go through court litigation. Why do we go through court litigation, through court system? Well, in principle, because as we know from the Charter of Rights and Freedoms, from the rule of law, justice in a broad sense has to be available to everyone. So the courts, they have to be open or available to anyone in case they had their rights violated or rights or freedoms abused, in case they are facing disputes in which the other disputing party does not do anything. So they need the court to help them have their rights experienced, enforced. So that's why the courts are always an option. Except, as we just learned, except when parties agree to arbitration. And if that agreement is valid, they have to go through arbitration. Now, as you saw from the case, even when you agree to arbitration, if you believe that agreement is not valid, yes, you can use the courts to challenge the validity of the agreement. Then the courts will decide and you'll go through the merits. So that's one important and main concept. In most democratic countries in the world, the courts, they are accessible by people in general if they have any issues. Let's say you received a fine, you want to challenge that fine, you want to dispute that fine. Again, you have a tenant, the tenant has not paid for the rent, so you want to sue them to get your rent paid. You want to get them out of your property. Immigration has denied or has done something related to your permit, so you want to challenge that. Well, again, any disputes in life we may be able to bring to court. So that's why justice has to be open, or courts have to be available to people in general. Now, when we talk about courts specifically, in Canada, procedures will vary by province. So in BC, certain procedures, in Alberta, other procedures. In general, I can tell you that procedures are very similar to one another, but they are not the same. So this is important for you to know as news, but it's very important for lawyers when they practice law, because if they are practicing law in BC, they have to be knowledgeable about the court procedures in BC. And if they go practice in another province, they need to become knowledgeable about those procedures. Trials are open to the public. Again, that's a general concept. And why? Well, because there's a concept or principle that says that justice must be seen to be done. So, for example, if you want to see a trial, you can go to Vancouver downtown, and you can attend a trial at a certain day. You just see the agenda there, and you attend the trial. So that's the general concept. And this also applies to you in case you sue someone else. If you sue someone else, or if you are sued, in principle, if there's a trial, the trial will be public. As you saw the decision from Uber Eats, the decision transcripts or the full decision will be published, will be made public. This is not the case as we saw for arbitration, for example. Now, there are exceptions to this. If the issue is about if it's child matters, if it's eventually family matters, eventually sexual abuse, sexual harassment. So there are certain circumstances in which the trial will be private, or even if they should have been public, the parties, they may request the judge to make the trial private for reasons they believe the judge should decide so. But the decision will be under the discretion of the judge. As a general principle, though, trials are public, so anyone can attend a trial. Now, let's differentiate a civil matter, and civil here means private, a civil matter from a criminal proceeding. So this course is not for criminal law, is not for criminal offense, but it's important to differentiate and to distinguish them. Well, a civil matter, a civil procedure is when one party sues the other, when one party starts a lawsuit with the other because they want the judge to give them a favorable decision. You caused damage to my laptop. I asked you to pay for the damage. You didn't want to pay, so I'm going to sue you. I'm going to start a lawsuit against you, and hopefully, based on the evidence and my claim and on the laws, I have the right to be compensated for the damage you caused me. Now, that's a civil matter. That's a private matter. So two private persons or parties or entities, they are using the court as a referee to their dispute. Okay? And that decision, the decision from the judge, is binding. So it's going to be enforceable. Now, how will the judge decide? The judge will decide on this principle that is known as balance of probabilities. Balance of probabilities mean more likely than not. So again, I'm suing you because you caused damages to my laptop and I want to be compensated for that. So I will show evidence. Maybe there's a document, there's a picture, there's witness, whatever evidence I have available, I may bring to court. Because by the way, the one who starts the lawsuit has the burden of proof. I am coming to court saying that I have a right and I want the judge to render a favorable decision to me. So it's obvious, or not only obvious is not the best word, but it's kind of logical and as a normal consequence that I have to prove that you actually caused damage to me. But the judge does not need to be 100% sure about my rights. That's why I have here under parentheses, more likely than not. So based on the evidence that is presented to the judge will decide that it's more likely that I am correct, that I should win the case than not. So that's what balance of probabilities means. Okay, more likely than not. This is different in criminal proceeding. So now, in a criminal proceeding, we're talking about a criminal offense. Examples: murder, theft, sexual harassment, abuses, many others. So when we talk about a criminal offense, the victim, does not go after the accused. It is the government. That's why I have it underlined to you. It is the government that will pursue the matter against the accused. The victim, what they will do, they will report to the police. The police will then investigate. The victim may bring more details, etc. But it's the police and then the prosecutor that will pursue the accused in court, not the victim. Why? Because it's a criminal offense. It's understood that it is the government that has to protect society as a whole. So it's the government that will prosecute it on behalf. It's the prosecutor on behalf of the government that will go after the accused. And what is the consequence for a criminal proceeding? Well, in a civil proceeding, actually, the consequence will be the remedy. I have asked the court. So usually money. In the example I gave you, I want money because you caused damages to my laptop. That's what I want. Now, in a criminal proceeding, the consequence is different. The victim doesn't get anything in return, but the accused, they may be sent to a hospital, to a probation center, or even spend jail time, even life sentence, sometimes capital punishment, not in Canada, but in the US and some other countries. So the government is the one prosecuting, the government is the one pursuing, and the government or the prosecutor, they have to prove the accused committed a criminal offense beyond a reasonable doubt. So in a private matter, as I just explained to you, the burden of proof is on balance of probabilities, more likely than not. But in a criminal proceeding, the burden of proof is much more strict. It's beyond a reasonable doubt. So the judge, to convict an accused, the judge has to be convinced beyond a reasonable doubt. Let's say the prosecutor was not able to find the gun for the murder, or there were no DNA evidences in the corpse, in the dead. Well, if there are any doubts, because the consequences of a criminal procedure, they may be so harsh that if there's any doubt, the judge has to acquit the accused. The judge cannot find the accused guilty of that criminal offense. Okay, so I only talk about criminal proceeding here to give you a differentiation aspect, to differentiate criminal proceeding from civil matter. This course actually will be focusing on civil matters, private matters. We won't be talking about criminal offense in this course. The concepts are different. And by the way, one restriction for your case law assignment, keep that in mind. You cannot have a criminal case unless the criminal case talks about the Charter of Rights and Freedoms. But if it's about a criminal offense, no, it's not allowed, because we don't study the criminal code, criminal law, and the concepts are different from business law, civil law, and it may confuse you. So no criminal law cases unless you got a criminal case that the merits are related to the Charter of Rights and Freedoms, such as the example I gave you in class, those friends who were found guilty for having over 30 kilos of cocaine in their car, but in the Supreme Court of Canada, they ended up being acquitted because the evidence was illegal based on section 8 and 9 from the Charter. So if you had such a case focusing on the Charter, that would be okay. So that's the difference between a criminal proceeding and a civil matter. Now, would you agree with me that one conduct may be both, may be a civil matter, but may also be a criminal offense? Can you give me an example? Can you think of an example of a conduct that could be both? And again, you can use the chat or the audio? What do you think? Any example? Think about a simple criminal offense. Anyone? Anyone out there? Robbery? Road violation as a hit and run? Yes, could be. Let's talk about robbery. Let's talk about theft. So theft is a criminal offense. We know that. Yes, it is. Now, if I am a victim of a theft, of robbery, I have to report to the police. As I just explained to you, it is the government that will pursue the criminal, the accused. But in a theft, if I were a victim of a theft, did I have any loss? When I am a victim of a theft, do I suffer any loss? What do you think? Yes. So, yeah, if my smartphone was stolen, yes, I suffered a loss. If my smartphone was worth $1,000, I suffered $1,000 damage. Now, in a criminal proceeding, will I get the $1,000 back from the criminal proceeding? What do you think? Yes, the answer is no. You are correct. In a criminal proceeding, they will pursue the criminal offense. So the prosecutor will pursue the criminal offense of theft and the consequences of theft. So there could be jail time, probation, etc. So what's my alternative? How do I get, or how do I try to get the $1,000 back to me? That's when it comes into play, the private matter, the civil matter. So I have to sue the accused, but when I sue, I'm suing in civil courts because of a civil matter. I am suing them, trying to prove on the balance of probabilities that they caused me loss of $1,000 because they stole my smartphone. So it's one conduct as the theft, but one conduct will give rise to two actions, two proceedings. One is the criminal one that is pursued by the government, by the prosecutor, and the other is the civil action, the court litigation, that is started by the victim in a way to try to seek compensation. Okay, so that difference is very, very important to understand. Maybe you can read later on, O.J. Simpson in the US passed away 1 or 2 months ago. So O.J. Simpson was prosecuted for the murder of his wife, but was never found guilty. And O.J. Simpson was not found guilty because the prosecutor could not convince the jury and the judge beyond a reasonable doubt that O.J. Simpson had murdered his wife. However, the family was able to get compensation in civil courts because the burden of proof for the family for their loss was on the basis of balance of probabilities, not beyond a reasonable doubt. So again, it's important to contrast those two proceedings and their consequences. Are you following? Any questions? Any comments? All good? Okay, so now let's talk about the court system. Well, when we talk about the court system, we'll be focusing only in this middle column here. We're not worried about the military or martial courts. We're not worried about the federal courts or even tax court. Okay, this course will focus only on the middle column here. So let's start with the Supreme Court of Canada. We just saw a case from the Supreme Court of Canada, Uber Eats. Well, the Supreme Court of Canada is the highest court in the country. There are 9 judges there. The Supreme Court of Canada will only hear appeals, so they are a review court, and they only hear limited appeals because there are only 9 judges and they hear appeals from all over Canada. Now, how do they limit the appeals they hear? Well, they will hear cases that they regard, they understand, of national relevance. So like the Uber Eats one, they understood that it had national relevance. Yes, there are many Uber Eats around Canada, and all of them have a in principle an agreement, binding agreement to arbitration. So all Uber Eats drivers in Canada, they have no access to the courts, for example. So they understood it's a matter of national importance. But usually they will hear matters of the Constitution related to the powers, provincial, federal governments, also Charter of Rights and Freedoms. They are the ones to hear appeals. And because they are the highest court in the country, based on the stare decisis principle, all their decisions will set a precedent. Okay? Because they are the highest one. So whenever they decide, that decision becomes a precedent. And then that precedent can be used in other cases. In future cases, that precedent becomes the law. Okay? So that's the Supreme Court of Canada, highest court in the country. Very few cases will reach the Supreme Court of Canada, and they are a review court. So the lawsuits will not start there. They will only review the cases. Now, each province will have their court of appeal. So it's a provincial court of appeal, and they will have trial courts. Some provinces will have 2 trial courts. Other provinces will have 1 only. But I'm talking about BC. BC has 2. So in BC, we have two trial courts. One is the provincial court, the lowest level, and we have the superior court. Superior court is the highest trial court. Okay? So what is the difference? Well, there are differences for family matters, for criminal matters, but our focus is civil, private matters. So for us, the difference will be related to money, monetary difference. Well, if you want to sue someone, or if someone wants to sue you or sue a company, if the matter is up to $35,000, they will start the lawsuit in the provincial court, in the lowest level court. Now, if the matter is over $35,001, they have to start the lawsuit in the superior court. Now, the Superior Court of BC is called the BC Supreme Court. Do not confuse the BC Supreme Court with the Supreme Court of Canada, which is the highest court in the country, as we just saw. They're different courts. So again, 2 trial level courts here in the middle, in the bottom part. If the matter is up to $35,000, you start in the provincial court. If the matter is over $35,001, you will start at the superior court. Now, after the trial, there's a decision. If the losing party is not happy with the decision, they may have grounds to appeal, to have that decision reviewed. Who will review that decision, the trial decision? It's going to be the Provincial Court of Appeal. So the Provincial Court of Appeal has similar function, not the same, but similar function as the Supreme Court of Canada. But they review cases coming from trial level courts. So cases from the provincial court or provincial superior court, when they are appealed, they go to the Provincial Court of Appeal. The Provincial Court of Appeal, they will review the case and they will say, no, there's nothing here to be changed. The appeal is dismissed. Or they will say, oh, wait, it seems the judge made a mistake here. There should be a different law or a different case law to be applied, or even the interpretation was not correct. So they may render a new decision. That new decision in the appeal is then the valid one. Whenever there's an appeal, could be to the Provincial Court of Appeal here or to the Supreme Court of Canada, always the last decision will be the valid one. Okay, so keep that in mind when you are researching cases. If you're researching cases for your case law assignment, if you find a trial decision, make sure that trial decision has not been appealed. Because if it has been appealed and if there has been an appeal decision, you should work on the appeal decision. That is the valid one. So, Provincial Court of Appeal, they review cases. Supreme Court of Canada, they also review cases. Now, let's say I start a lawsuit here. So the Uber Eats example. The driver started the lawsuit here in the Superior Court. The judge, the trial decision, the challenge for arbitration was favorable to the driver. So Uber Eats appealed to the Provincial Court of Appeal in Ontario. The Provincial Court of Appeal decision was also in favor to the driver. Then Uber Eats appealed it further to the Supreme Court of Canada. Then the Supreme Court of Canada had the final decision. Now the case goes all the way back to the trial court so that the trial court can look at the merits. Okay, so now, as I said before, each province will have their own court of appeal and then the trial courts. Now, with regards to precedent, decisions from the Court of Appeal of BC that are final, they may set a precedent, not all of them set, but they may set a precedent, but that precedent is only binding in BC, in the lower judges from BC, not from other provinces. The precedents set by the Supreme Court of Canada, they are binding all over Canada because the Supreme Court of Canada is the highest one. Their decision is final. However, the decision from the Provincial Court of Appeal of any province, so we're focusing in BC, a decision from the Court of Appeal in BC that sets a precedent is binding only on BC judges from lower courts, not from other provinces. Judges from other provinces, yes, they can use the BC precedent. Yes, they can, but they would use as persuasive. They would use it because they find it's relevant for the case they have at hand, not because it's mandatory. Different from judges in BC. Judges in BC, that decision is binding. They are required to follow. Okay, so as a review, as I said to you, the trial courts, they are the provincial or the superior court. So we have to decide, and I expect you remember, and you will have quizzes on that, your exam will have questions on that. Where should the lawsuit start? Should it start at the provincial court or at the superior court? Well, for us, it's going to be decided on monetary amounts. We're not focused on family matters or criminal matters, etc. So the provincial court, as I said, is the lowest level court, and they have a division that is called small claims court. So the small claims court, they get cases up to $35,000. You don't need a lawyer. You can have one, but you don't need to, because the procedures are simplified so that people have more access to courts without the expenses of a lawyer, other legal fees, etc. But again, if you want to have a lawyer, you can have one. Now, let's say you want to sue someone for $40,000 over the 35,000 limit. Now, you would come to the superior court, and in BC, it's called the Supreme Court of BC. But here you have to hire a lawyer, so costs, you have more costs. Eventually, you may sue through the small claims court, and in your claim, you would limit to $35,000. So you are waiving $5,000 that you believe you are entitled to. Okay, so you could do that if you wanted. Now, there's another court that was created some years ago, and it's called the Civil Resolution Tribunal. So they are part of the Small Claims Division. The Civil Resolution Tribunal, available here in BC, they take matters up to $5,000. So now there's a further division in the provincial court level. The further division is, if your matter is up to $5,000, you start through the CRT, the Civil Resolution Tribunal. It's an online tribunal. You also don't need a lawyer. You may have one if you want. And you do it online. Update your evidence, just describe your claims as if it was an essay, etc. So it's very simple. Now, if the matter is over $5,001, but lower than $35,000, then you go to the small claims. And then if it's over $35,000, you would go through the BC Supreme Court, okay? Because they have unlimited monetary amounts. Are we good so far? Okay, so now, Provincial Court of Appeal, as I said, they are the highest court within the province, not the highest court in the country. So within the province, they are the highest court, and they will review questions of law. Very rarely they will review questions of fact. So what are questions of law? I told you already. Questions of law are, well, did the judge apply, did the trial judge apply the correct law, the correct case law? Did the judge interpret that law correctly, etc.? So those are questions of law, okay? I'll give you examples of questions of fact later on. As I said, here I'm saying there's no new trial, so they will review the trial, and they will either agree with the trial's decision or they will render a new decision based on their interpretation. Then the Supreme Court of Canada, as I said before, highest court in the country. They also only review cases, and their decisions set a binding precedent because they are the highest court in the country. So again, I expect you to remember the court system, and you know how to navigate what they do, where you should start one or the other. Now, we have two more concepts before we go through the litigation process itself. So the first concept is known as the limitation period. What is the limitation period? If you want to sue someone because you were a victim of an event, so let's say, I'm going to use my example, you damaged my laptop in class. So the limitation period says that I have up to 2 years to start the lawsuit against you. If I take longer, I am barred from starting that lawsuit. This exists so that I am not sued, or defendants are not sued for situations that took place 5, 10, 30, 100 years ago. The evidence is not available anymore. There are no witnesses anymore, etc. So for us, why is this important? From a legal risk perspective, it's important that if you were part of an event that may give rise to a lawsuit, keep in mind that you have up to 2 years. Well, 2 years is the general rule. There are cases, for example, human rights complaints, you have to start a complaint up to 1 year after the discrimination. But 2 years is the general limitation period. So keep in mind you have to start a lawsuit up to 2 years. And then you could think, well, why would I wait up to 2 years or close to 2 years? Well, eventually you are saving money for the legal costs. Eventually you're trying to negotiate with the other party without the need to go to courts. Or you are shopping around lawyers. You go to one lawyer, you don't like them, you go to another. Well, there may be reasons. Or you are still getting more evidence, etc. So there may be reasons you are still waiting to start the lawsuit. But remember, up to 2 years. There are some criminal cases, for example, child abuse, they have no limitation period. So usually an adult, after they go through counseling and some other issues in their lives, they realize that when they, in their childhood years, they were abused. So they can report to the police, prosecutor may start investigation. So this is one example, there are others. Criminal offense, for that specific criminal offense, there's no limitation period. I'm sharing this as news to you. What is important to us is to understand the concept of limitation period. After some time, the general rule for private civil matters is 2 years. You cannot start the lawsuit. Okay? Now, another concept for us is jurisdiction. What does jurisdiction mean? Well, it means the place where what court can adjudicate the dispute. Or in other words, where should the plaintiff is the one that starts the lawsuit. Where should the plaintiff start the lawsuit? So if I want to sue you because you damaged my laptop, where should I start the lawsuit? Will I sue you here in Vancouver? Will I sue you in Ontario? Will I sue you in Brazil? Well, the place means jurisdiction. In legal terms, it means what court has the power, has the legal power, legal authority to adjudicate the dispute. Okay? So here, there are also several rules, but for us, we'll keep in mind the main rule. The main rule is where the defendant is the one sued. So where the defendant resides, where the defendant lives. So if you live here in Vancouver, you will be sued here. If you live in Ontario, you will be sued there. So it's the general rule is where the defendant lives. One exception I can share with you, for example, car accident. If there's a lawsuit about a car accident, it's on the place where the car accident took place. For example, 2 BC residents were spending summer days in Alberta and they were involved in a car accident. Then one decides to sue the other. Okay, I know there's insurance that covers, etc. But let's say there's a lawsuit because of that car incident. The lawsuit has to be started there in Alberta, even though both the plaintiff and the defendant are BC residents, but the event took place there. Okay, so but that's just one exception. You don't need to know the exceptions. You need to understand what jurisdiction is, because throughout the course I may refer to jurisdiction. No, you cannot start it there because that court has no jurisdiction. Then you should understand what jurisdiction means. Okay, so it's the place where the court that has power to adjudicate the dispute. All right, so now with regards to the process of civil litigation, the lawsuit itself. So let's say you decided to sue someone, you hired a lawyer. So what will the lawyer do? Well, first of all, the lawyer will determine the jurisdiction, where to start. So it's the job of the lawyer. Where should I start the lawsuit? Should it be Vancouver, other province, etc.? Then the lawyer will prepare the documents that are called pleadings. So the lawyer will prepare the statement of claim. The statement of claim is the document used to start the lawsuit. In the statement of claim, the lawyer will describe what the event was, the rules, the laws, the case law, everything that should be applicable in that case, and the claim or the remedies that the plaintiff wants. Now, you should know the terminology. Plaintiff, again, is the one that starts the lawsuit. Defendant is the one that is being sued. So the plaintiff is usually the victim. If you caused me damage, if you caused damage to my laptop, I was a victim. So I will start the lawsuit against you. I will be the plaintiff. You will be the defendant. So it starts with documents, and then there will be discovery of evidence. So discovery of documents, witnesses, etc. Parties can try to settle. So a settlement is always available. Parties can settle at any time before the trial or even after the trial. But if there's no settlement, after the trial, the judge will render a decision. Usually the decision is rendered in writing. That's why, for example, we saw the transcripts or the decision from the Supreme Court of Canada. So this is in a very nutshell. I have a video for you, but just for time, I have shared that link with you. So I will not play the video now, but the video I shared through Learning Hub with you is this one from this Josephson Litigation Council. I'm not affiliated with them. It's just that because I'm not a licensed lawyer in Canada, so I've never been in a courtroom as a lawyer. I decided to have, I found a video, and this one, it's a 6-minute video, no less, 5-minute video that explains all the steps, 10 steps of the litigation process. You will not be examined on this, but it's very informative to watch this video. So the link is on Learning Hub again. You can watch this later on, and you're most welcome to ask me any questions you may have. Don't stick to details, but try to have an overall understanding about the lawsuit, how it is. Again, how it starts, the process, the steps, until the final decision, how it is. Okay, so let me click back here. Now, here. So that's, in a nutshell, how the process of civil litigation is. The documents, I just talked about the documents, and then the discovery. Discovery meaning presenting evidence to the court. It could be that the other party has an important document that they should disclose, they should bring to court, or it could be that you have a document or a witness or something relevant to the case. You may bring it. And then there will be the trial. Remember, I mentioned this before, I reiterate here now. The plaintiff has the burden of proof. So I started the lawsuit against you. So I have to prove I have a right. I have to prove you caused damage to my laptop, for example. Now, it doesn't mean that you don't need to bring any proof to the case. Now, if you are a defendant and I'm suing you because allegedly you caused damage to my laptop, but you have evidence that you were out of town that day. You have air tickets, you have witnesses. So even though you don't have a burden of proof, but you can bring that evidence to make my life as a plaintiff more difficult to prove my case. But that's important to keep in mind. Now, the judgment itself, the decision. So in both civil and criminal trials, there may be a jury. A jury is not so common in a civil, in a private matter. Why? Because it's more costs. Parties will have more costs if they have a jury. But if there is a jury in a civil matter, then the jury will decide questions of fact. And the judge will decide questions of law. So what is the difference here? Well, questions of fact are related to fact. So for example, is it raining today? It's a fact. It's not a legal aspect. What else? Was it night when the accident happened? Was it day? So those are facts. These are decided by the jury. Once the jury decides the fact, then the judge applies the law, decides on the law based on the factual decision. But in most lawsuits, most litigation, there's a judge alone. And when there's a judge alone, the judge decides both the questions of fact and the questions of law. Now, I don't know if you saw last year, but it was famous last year, the defamation case from John Depp against Amber. It was even broadcasted live, etc. So there was a jury in that case. It was not a criminal, it was a civil case. So the jury decided that, yes, some statements were defamatory. So that was a factual decision. And based on that decision, the judge decided to award millions of dollars to John Depp. So it's a simple, real example to show you how things work when there's a jury. When there's no jury, the judge decides both questions of fact and questions of law. Now, remember that the appeal court and the Supreme Court of Canada, they will mostly look at questions of law, not questions of fact. There are few exceptions in which the Court of Appeal of a province will look at questions of fact again, but this is an exception. We don't go through those exceptions. Now, there may be legal costs, and there are legal costs in a lawsuit. So usually the judge will award the legal costs, the reimbursement of legal costs to the winning party. And I say usually because in very few circumstances, it could be that the judge awards to the losing party. But that's not common. It's just if the winning party caused any issues, matters, troubles during the litigation. In most cases, either parties will bear their own costs or the winning party will be awarded the legal costs. Now, why is one party suing the other? Why am I suing you? This is the question I'm going to answer after the break. So let's break for 10 more minutes. Let's be back 11:13, please. So I briefly discussed with you how the litigation process is. Then there's a decision. But the question I gave you before the break, why does the plaintiff sue the defendant? Well, the answer to this question is, in most cases, not all, but most cases, and when I say sue, I'm referring to civil matter, private matter. So in most cases, the plaintiff is seeking money, monetary compensation. And in law, monetary compensation will be damages. So I expect you to remember those types of damages. There are several types of damages, but the three main ones are this: the special, the general, and the punitive ones. So when I sue you for $1,000, this is the damage you caused to my laptop. So I'm going to seek in court what is called the special damages. So special damages are those costs that the plaintiff or the victim actually incurred, and that's why they are suing. Now, there's another type of damages that are classified as general damages. General damages are related to future costs or costs that cannot be precisely calculated at the time I start the lawsuit. Could be pain and suffering. Could be because of your damaging my laptop, I started to develop anxiety, some other mental issues. Then I couldn't go to work. I had lost wages, etc. So I would sue you for special damages, $1,000, plus general damages because of my suffering and those other issues. Another type of damage is known as punitive damages. Well, they are awarded by the court when the court wants to punish the defendant. They want to punish, or they want to teach a lesson, not only to the defendant, but to society as a general. So one example here is, and this is usually could be for employment lawsuits, but also common in consumer transactions. So one example is almost 40 years ago, this lady bought hot coffee through drive-through at McDonald's in the US. And after they drove out, the coffee spilled on her lap and she had burns of the 3rd degree. The evidence in the case showed that coffee was almost 3 times hotter than the temperature we usually brew coffee at home. Coffee was filled to the top in the cup. There were no hot caution notices or disclaimers. So in that lawsuit, the plaintiff was awarded special damages, general damages, but also punitive damages. So the court awarded 1.3 million, the trial court, to the lady. Now, McDonald's appealed. The Court of Appeal reduced that amount to around 700,000. And then after the appeal, the parties settled. And the settlement terms were never made public. But this is an example. So the court here, their aim was not to give extra money to the plaintiff. No, the aim here was to teach a lesson to McDonald's and to the whole hot drink industry that whenever they are selling hot drinks, they should train their employees well. They should review their processes of making the hot drink. They should add those disclaimers, caution notes in lids, cups, etc. So that's the idea for punitive damages. So mostly used for consumer transactions, eventually employment too. But I say mostly, not always, not only, could be other cases too. Now, there are other types of remedies, but those other types I will discuss with you as we move forward with the course, when we talk about contract law, when we talk about torts. For now, I just want to talk about declaration. Declaration as a remedy. Well, I am suing and I want the court to declare something. Well, what is the best example here? The best example is that charter lawsuit I shared with you. Those people who were acquitted from drug trafficking by the Supreme Court of Canada. Because the Supreme Court of Canada declared that the illegal evidence obtained by police could not be used in the prosecution. So that is a declaration. Now, it could be that you are suing. Let's say another example would be, I have a brand and someone else starts using my brand, and then I want the court to declare that I am the real owner of that brand. And based on that, I want them to stop using my brand, etc. So this is usually when the court declares something is legal or illegal, and then other consequences. So that's an example here for the declaration remedy. But in civil private matters, the main remedies will be damages. And again, I expect you to remember the difference between special, general, and punitive damages. There are other types of damages, just to let you know. Now, I sued you because you caused me, allegedly you caused me $1,000 damages, and I won. Oh, I won. So I won $1,000 from court. Now, I expect you to voluntarily pay me. If you don't, I may use the court to help me enforce my judgment. So the first message here is that the fact that I won the lawsuit does not guarantee that I will get the money, because it may be that you don't pay me. Or it may be that you don't pay me because you don't have assets. You have no money available. You have no other assets. You don't work. So you cannot afford. Now, what happens? So this is something that you have to assess. This is something that you have to explore before starting the lawsuit. Because when you start a lawsuit, you have costs, you spend energy, etc. What if you win, but then the losing party cannot afford paying you? Eventually, you should have decided differently. I'm not saying you should not sue, but I'm just saying that this is a consideration you have to make before starting the lawsuit. Is it actually worth starting the lawsuit? So this is something you should keep in mind. Now, if the defendant does not pay you voluntarily, you can use the court to help you enforce your judgment. And this will apply the same if you have an arbitral award, an arbitration decision. An arbitration decision that is not complied with voluntarily by the losing party, they can be enforced through courts as well. So you get the judgment, and then you would have the defendant to come to court along with you, the winner. So the creditor is going to ask questions to the debtor, to the defendant, so that they want to try to find personal property or real property, could be wages or any debts they have. So the idea here is that the court will help you try to find assets from the losing party. And then if those assets are found, the court may seize those assets, and then those assets will be sold. The proceeds of those sales will be used then to pay debtors. Okay? Again, I'm giving you the very broad overview of enforcing a judgment. Now, what if you don't have money? Let's say I was the defendant. I lost the lawsuit. I would have to pay $10,000, and I don't have the money. I don't work. I have no assets. Can I ever go to prison because I cannot pay a judgment award? What do you think? Can a judgment debtor go to prison? Anyone out there? You say yes, yes. I'll tell you what. Not in Canada. In Canada, you don't go to prison if you can't pay a judgment award. In Canada, you may go to prison if you are convicted of a criminal offense, but not if you cannot afford a judgment award. There are some countries that, yes, if you can't pay a judgment award, one of the consequences is being imprisoned. Even in Brazil, if you fail to pay child support, to make child support payments, family payments, you may be in prison for some time. But that's the exception. And some people even say that there in Brazil, it's against human rights law. But there are some countries that, yes, you may go to prison if you, even if you don't have assets. So one consequence is going to prison. Not in Canada. In Canada, what you can do as a plaintiff, you can wait for some time, or you can file for their bankruptcy. But no, the defendant will not go to prison. So yeah, keep that in mind. There's no prison for owning a judgment award. So that's the litigation process. Again, it's private in nature. The court, the judge, is used as a referee, and the plaintiff starts with the documents. The defendant will present their defense. There will be discovery, eventually a trial, the decision. In the decision, there will be the remedies that were asked for. That decision will be enforced, as we just saw. Yes, and that's how a lawsuit will go. Now, we go through this concept of class action. What is a class action? A class action is when there was an issue. So it's a similar type of injury or issue from the same defendant. So let me give you a real example here. So where's my browser? Okay, right here. So let's get the Facebook class action. So here, there was a class action. So how does class action work? First of all, one person, one plaintiff, starts the lawsuit. And then when they start the lawsuit, they try to convince the judge that the type of injury they suffered also affected several people, an identifiable group of people. And the wrongdoer, the entity or the party or the person that caused, is the same one, in this case, Facebook. So this was an issue. So allegedly, Facebook violated the privacy. So Facebook, former Facebook, now is a Meta company. So they had sponsored stories, and they used the image of some people without those people's authorization. So it was a violation of privacy issue. And the court, yes, classified. So it started here in BC, by the way. And the court classified, the judge accepted to classify as a class action. So then you can read it later. This is still open. You may be able. So there was a settlement. Facebook settled for $51 million. Usually companies will settle when they are suffering a class action because they don't want to be exposed. They don't want the bad reputation. They don't want to have to show evidence, documents, etc. So in most cases, not all, but in most cases, they will settle. So there's a settlement here for $51 million for everyone. Now, I'll explain to you how this works. Well, that individual starts the lawsuit. Then if the judge agrees, the judge classifies as a class action. Now, after the class action is classified, is granted, then anyone who suffered the same injury or damage or violation from the same defendant, they can choose to opt in to that same lawsuit. They don't have to. Well, they cannot sue individually because once there's a class action, that same situation can only be solved through the class action. Now, people can opt in or they just don't bother. Now, why does this exist? Well, it exists. The class action exists to avoid inconsistent decisions. So I explained to you that judges in Alberta may decide one way. They may have to follow a certain precedent. But judges in Saskatchewan, they can decide differently. Judges in BC could also decide differently. And the company is the same. The event was the same. So the idea here is to get together and to have only one lawsuit about that event and that same defendant and render only one decision. If it ever has a trial, because like in this case, there was no trial. Facebook offered a settlement and the settlement was accepted. Now, if you read here, if you were, what is the settlement terms here? So they're saying that if you were a natural resident from BC, Saskatchewan, Manitoba, or Newfoundland and Labrador, and you were a member of Facebook from January 2011 to May 2014, and you register your real name, and you had your profile picture as an identifiable self-image, or your real name, portrait, or both were used in a sponsored story, you may be entitled to the settlement here. I don't know how much each person will get. Okay, here it's saying. So the maximum payment for each person will be $2,000. So you see, if you meet one of these criteria here, you would then, if you want, you would then submit your claim here. You would say that yes, you meet this criteria, and you may eventually be paid $200 for that. Okay, so the $51 million will be used to pay this amount for each individual that has opted in, also legal fees, lawyers' fees, etc. Okay, so that's how a class action works. Once the judge classifies a lawsuit as a class action, any victims that meet the criteria of the event, they will either opt in or they will just don't bother. So it's not a surprise that many people are not even aware that their image and real name were used by Facebook in a sponsored story, and they would be entitled to this. And here, another disclaimer, I'm not advocating against Facebook or anything. I'm just showing you a real example of a class action. There has been several. There has been a class action from Life Labs, from Samsung, from Apple, from many companies, from car manufacturers. So all BMW, Ford, Volkswagen, many manufacturers, because there was one incident from the same defendant that may have affected a lot of people. Keep in mind that you start the lawsuit individually, and then the judge will decide to classify it as a class action or not. Okay, it's at the discretion of the judge. All right, any questions on class actions? Nope. Okay. So this is the last topic of the class. The last topic is named as regulatory body, but it also involves administrative tribunals. Now, what is an example of an administrative tribunal? I gave you since first lecture, the Human Rights Tribunal. It's an example of an administrative tribunal. Another would be human rights commissions, could be the workers' compensation boards. So let me get back here to our court court hierarchy. I didn't emphasize this at that time, but I will do now. So you see here in the very bottom here on the left, you see the Provincial Administrative Tribunal. So even though the Administrative Tribunal is here in this outline of the Canada's court system, those administrative tribunals, they are not part of the court system. Those administrative tribunals, they are part of the executive branch. So remember, you should know those concepts as we talk about them. So the administrative tribunal, they are part of the executive branch. And why do they exist? Well, they exist because politicians or the government, when they passed a new law, when they passed legislation, they decided to create a specific tribunal for a specific matter. So when the human rights laws were passed, politicians and the government, they decided that they wanted a specialized tribunal to render disputes on discrimination, on human rights issues. Now, it's not part of the court system. However, they function similarly to the courts because they hear disputes and they render decisions. And their decisions may include compensation, orders for correction, for training, for apology, many orders. They may grant rights, they may deny rights. So even though administrative tribunals and also regulatory bodies, they are not part of the court system, they have to follow some legal principles that are important for us to know. Now, let me give you examples on regulatory bodies. Regulatory bodies are any governmental bodies or departments that either grant a right or deny a right. So an example would be, if you want to start a business, you have to apply for a business license. Where do you apply for a business license? Who would give a business license for a new business? Does anyone know what department you apply for or what regulatory body? I think I mentioned in our last lecture. Any guesses? Municipal? That's right. Yes, that's the municipality. If you want to start a business in Burnaby, you go to the Burnaby municipality, apply for a business license. You would do the same in Vancouver or New Westminster and, well, all other cities. Well, they are an example of a regulatory body because when you apply for a business license, that business license is either granted or denied. Another example would be Health Canada. Health Canada has to approve a new medicine, a new drug, a new vaccine, a new treatment, a new machine that is used for treatment or diagnosis, etc. So anything health related, or most things health related, they require an approval from Health Canada. So Health Canada is also an example of a regulatory body. So both administrative tribunals and regulatory bodies, they render decisions, and their decisions may affect the rights of people, of institutions, of companies. So that's why they have to follow some legal principles. And that's the idea here of this last slides. So why do they exist? They exist usually because they have a specific expertise in that given matter. As I said, human rights, employment matters, labor. It's not that courts, judges don't know about the issue. It's just that politicians wanted specialized people to look at those issues. And because they are not part of the court system, they are usually more efficient, they are quicker. So some advantages of them. Now, I have underlined here for you in the slides. The processes may be reviewed, not the merits. The merits only on exceptional cases. And you will hear from me a lot of times the word exception, but I will never be emphasizing on those exceptions, because exceptions would be for future lawyers, law school, etc. For us here, I mentioned exceptions because I don't want to give you the impression that it is only that and that's it. No, there are exceptions in which courts would review the merits. But in most cases, courts will only review the process. So by process, I mean, I filed a human rights complaint. No, let's say you filed a human rights complaint against me. Allegedly, I discriminated on you. Now, let's say you presented evidence and the tribunal did not allow me to present my evidence. Well, this is not correct. This is against the natural justice rules. So in this case, I would go to court so that the court would review the process of the Human Rights Administrative Tribunal. Okay, so I'm not going to court for the merits. I'm not going to courts to defend myself from the discrimination allegation. No, I'm just saying, hey, court, can you get back to the tribunal and ask them to correct their process? So that's what courts would do. They would eventually correct processes, but not the merits, unless it's an exceptional case. So courts, they want to assure that procedural fairness is complied with, is respected with administrative tribunals and also regulatory bodies. So they want to make sure that there's a law that's established that administrative tribunal or the regulatory body, and the law gives power to those decision makers to make a decision. They also want to make sure that the process is fair, that the rules of natural justice are complied with, are followed, such as there's a fair hearing for both parties, the decision maker is impartial, there's no bias. And by the way, those fundamental justice rules, or those principles, they are also applicable to private companies, as I'm saying here, also private institutions. So let's say at your company, let's say someone accuses you of harassment or of bullying. You are entitled to a fairness of process. You are entitled to a fair hearing. You are entitled to an impartial decision. So this is applicable not only to administrative tribunals, regulatory bodies, but also to private companies and institutions. Now, the courts, as I mentioned before, courts will review the process. So when courts review the process, what do? They look at the statute. Is the statute that created that regulatory body or administrative tribunal, is that statute valid or is it invalid? Was the decision within the parameters that is allowed by the law, or was the decision beyond the parameters and the authorization? Were there any errors of law? Was there a failure to follow procedural fairness or the natural justice rules? Did the decision maker or the tribunal itself abuse on their discretionary power? So those are all issues that courts will go through in order to assess whether the process was okay or not, whether the process needs to be corrected or not. And then Remember when I mentioned to you the declaration remedy? So a declaration remedy is used here a lot for the review of processes. So courts, they will declare whether a law is legal or illegal, or whether the remedies were correct or not. So courts would then declare. They wouldn't be awarding compensation in those cases, for example, in the review cases, administrative review cases. Yeah, so that's the end of chapter 3, where we went through resolution of disputes, and we looked at the alternative ways: negotiation, mediation, and arbitration. And then we looked at the court system, how the litigation process works, and we ended up with this regulatory body and administrative tribunal concepts, legal concepts that are applicable to them. Let me stop the recording here. And questions?